Good afternoon, everyone. Welcome you to the webinar on India's new labor regime. Thanks to everyone for joining us. And before we begin the subject, I quickly introduce our speakers and also share the session's flow. Our experts for today's topic are Ms. Anjali Malhotra, who's a partner regulatory, and Mr. Sandeep Jhunjhunwala, who's the partner tax and regulatory at Nange & Co. While Sandeep and Anjali will share a presentation, you may I hope everyone is able to hear me. Yeah. So while Anjali and Sandeep will share a presentation, towards the end, they'll open up for a Q&A session, and you may please put your questions in the chat box. So we'll try and address all the questions within the Q&A session. In case we miss out on answering any, you may please share your email address also in the chat box, and we'll try and ensure that all the questions are answered. So over to Sandeep and Anjali, and hope you enjoy the session. Thank you.
Thank you, Urvishi, for the introduction, and thank you all for sparing such a time to hear to us and have some insights on the labor codes. As you can see that our topic is new labor codes, and this is towards the Aatmanirbhar Bharat, which is the mission of today's India. Towards that, as you are aware that all the four labor codes has now been made effective, and the effective date which has been announced is 21st of November 2025. We all need to gear up with the labor codes, and I'll take you through that what are the important impact areas where we need to focus as on date so as to prepare ourselves towards the implementation of these codes. So if we talk about broadly that what codes are there, I would say there are four labor codes. One is code on wages, code on social security, code on occupational health and safety, and code on industrial relations. What was the rationalization? What was the objective of these labor codes? So rationalization of the existing labor codes was the main objective. That is, we need to have a consolidated labor codes. Right now, we were having 29 codes acts as on date. We need to subsume all these. And this has now 29 acts have been subsumed into the four codes. Effective date, as I mentioned, the 21st November is the effective date. But until the transition is complete, because the draft rules are there, rules have not yet been notified. Till the time the rules are not notified, rules are not there, till the time our old provisions will remain into effect. But what we need to see is which are the provisions which now need to be implemented, which are the provisions which will be in effect till the time we have the codes or the rules in place. Why these new labor codes are there? So the objective was that colonial era structures are still there. Those were not addressing the needs of the business. That's why these new codes have been brought into effect. This codes empower both workers as well as the industrial entrepreneurs as well. This builds the workforce more protected and productive because the workforce will feel more protected because the laws are towards the. Sorry, there is too much of the disturbance because of this. Saurabh, can we stop this? Okay, I think that's better. So the workforce feels more protected because the rights are being granted to the workers as well, and more responsibility is casted on the employers to safeguard the interest of the workers as well. Keeping in view, the new codes pave the path for more resilient, competitive, and self-reliant nation. Taking on to the codes, I'll broadly take you through that what is subsumed into which codes. Code on wages subsumed four of the acts which are related to the payment of wages, minimum wages, payment of bonus, and equal remuneration. Code on social security broadly subsumes the Compensation Act, Insurance Act, Employee State Insurance, the Provident Fund benefits, other maternity benefits, etc., which are more related to the social security of the employees. Code on occupational health and safety working conditions subsume the codes which are sector specific. For example, the codes were there, separate codes were there for the laws were there for the purpose of working journalists, for sales promotion employees, for interstate migrant workers, for journalists, mines, plantation, and factories. So these codes have been subsumed into the occupational health and safety codes. Industrial Relation Code subsumes the Trade Union Act, Industrial Employment and Standing Order Act, and Industrial Dispute Act. So this gives you a broad perspective that what acts have been subsumed into the various codes. Coming into the states, most of the states have notified their draft rules. Draft rules have been pre-published for the public comments. States have received the public comments as well, but there are still some of the states which need to be ready, prepared for the remaining pre-published notifications towards the rules. So the snapshot is there in our presentation that which states have come out with the pre-published rules. Sandeep, we can't see the presentation on the screen. If you can share that. Okay, so this snapshot is just for the reference, but I will hand over it to Sandeep to take you through the two codes, that is code on wages and code on social security. Sandeep, over to you. Sandeep, are you there? Sandeep, I can't see you on the screen. Hello. I think we are facing some technical issue, but in the meanwhile, Urvashi, can you check with Sandeep? We are checking just be there on the webinar. We are just checking if Sandeep is somehow not able to join. We will take rest of the two codes and then probably Sandeep will take you through the other two codes later on. We are just checking. Next share my screen share. Sandeep, are you there?
Hi, am I audible? Am I audible, Anjali?
Yes, Sandeep, now you are audible.
Sorry, there was some issue at the technical side. Let me just present the screen. Is my screen visible?
Yes, Sandeep, it's visible now.
Yeah, hi. So good evening, everyone. I'm sorry for this interruption. At back end there was some issue, but I'm here to take up the discussion on the labor codes, specifically concerning the code on social security and the code on wages. Now, before we dwell a bit deeper into this, as we might know that the labor as a subject, as per our constitution, is on the concurrent list, which means that both the center as well as the state have the rights to legislate the law. Take it something similar to a RERA or a GST, for example, where the center frames the main statute, the main act, and then it allows the states to frame the rules based on the model, the rules which is also released by the draft for reference purposes. So while they cannot breach what the center has to say, but the states have all the liberty to frame the rules around the main objective for which the central law has been created. I think we have multiple laws in the country, as I gave you example on RERA and GST, which probably work on similar kind of structures. Now, of course, that goes with a fundamental rule of interpretation that if there is any conflict between the central and the state law, then the central generally prevails. So in this case, as well, since labor is a part of the concurrent list as per the constitution, the center has already released the model rules for all the states to refer to. And in fact, if you look at the slide, most of the states have also released their draft rules. Now, of course, this has been in discussion for almost 4 to 5 years now. So some of the rules were released by the states way back, say in 2022 or 23, and maybe after the effective date getting notified now as 21st November, states may still want to relook at the rules, the draft which were released earlier, and try and see if there is any need for changing or making more modification for the on the rules before it is getting before it gets finally notified. So as we see on this slide, at least most of the states listed out on this slide have already released the draft rules. Now, if we move further, uh, on the second slide, on the second slide, all these states again have released the draft rules, except, for instance, Tamil Nadu, which is yet to release the rules on code on social security. And the third one, where we see West Bengal, which has not released any of the rules so far, and states like Delhi, where one of the rules has only been released, and the balance three rules have still not been put in place, even as draft for public consultation. So this is where we stand as far as the state rules are concerned. Now, before we go into the code on wages, I think two, three aspects that we probably need to understand. One is the center has already notified the effective date as 21st of November, while the state rules have not been notified yet. So one question that comes to everyone's mind is that what is the status as on today, with the center having released and making the effective date as November 21st, while the state have still not notified the rules. I think here what we need to be mindful of is that maybe it gives some time for the companies to look at the way these labor codes are going to bring in changes as far as their PNL or their working capital is concerned, as well as maybe on the process. Just to give you an example, we'll we'll talk about it, a little more deeper as we proceed. But some of the PNL impact could be, we're going to talk about the gratuity for fixed term employment, full and final settlement to be released within 2 days after resignation. There is a contribution which is required to be done by the aggregators, for the platform, the gig workers, and also for construction companies for the construction workers. Leave encashment has to be paid at the end of the calendar year as per the code. And bonus has to be paid within 8 months from the end of the financial year. So all of this is going to have some P&L impact. Whereas there could be scenarios where there are process impact as well, where, say, for instance, there's a requirement to have a crash. There is an annual health checkup requirement for workers beyond 40 years. Contract labors are not permitted, or they are prohibited in the case of core activities of any business. So overall, there is going to be a P&L impact and a process impact. I think this gives time to the companies, the employers, as well as the employees to probably look at the way this code is going to bring about the changes in due course of time. Also, one important fact is that since this is a consolidation of the code, this is not a revamp per se. It's a consolidation of some of the older statutes which were already there. There are a lot of repeats, or there are a lot of as-is provisions which have been brought into the statute or in the new code. So we will focus on the key changes because we are going to cover 4 codes. So for the purpose of this discussion, we are going to focus on some of the key changes. Now, dwelling a little deeper into the code of wages, which is our first code, I think one has to be mindful of 3 key definitions before we get into the code of wages. One is the definition of wages itself. The second is the definition of employee and worker, because many of the provisions are applicable only to employees and some of the provisions are applicable to workers, while there are few which are applicable to both. And the third definition, which is very important through the course of this discussion, is the definition of establishment and factory. Now, establishments and factory again are to be distinguished because some provisions applies to only establishments, some applies to factories, whereas there are few which applies to both. So to start with, the code on wages, as we know, is a code which uh, kind of consolidates four laws, which is Payment of Wages Act, the Minimum Wages Act, Payment of Bonus Act, and the Equal Remuneration Act. It regulates the payment of wages to employees. It fixes the minimum rate of wages to the specified employees. And this is where we will have to wait for the states to come up and specify the minimum wages. This talks about the payment of bonus to employees and the equal remuneration in all matters related to employment, which in some sense was already there. Now, some of the key aspects that one has to be mindful of when we go over the provision of the code on wages is one, that there is a requirement of full and final settlement, which is required to be done within 2 working days of removal, dismissal, retrenchment, or resignation. This is going to be very key aspect. The definition of wages, which we are going to deal with. There's also a requirement for overtime wages, which is to be paid not less than twice the normal rate of wages, and the specification on the working hours, which which it clearly mentions that it has to be not more than 8 hours a day with a rest period of around an hour. Now, the main essence of this entire code, of in fact all the four codes that we are going to discuss, including the code on wages, lies in the definition of wages itself, because a lot of entitlements that we are going to talk about will depend on the definition of wages itself. Now, one thing that we note is that in the course of simplifying the term wages, it is actually not simplified, and the way it has been structured or the way it has been defined, it actually is not free from multiple interpretation. So to break the definition of wages and to simplify it for the participants, it actually consists of three main blocks. One is the inclusion, the second one is exclusion, and the third one is a conditional inclusion. So what is included? What is included is basic pay, dearness allowance, and retaining allowance. So that is clearly included. What is clearly excluded is some of the terms which are mentioned on the gray box in the middle of this slide, which is, say, for instance, bonus, HRA, any PF contribution, conveyance allowance, house rent allowance, any kind of a overtime allowance or a commission. So this clearly falls under the category of exclusion. And then we have a third category, which is called conditional inclusion. And the conditional inclusion is coming because of the fact that the code requires the exclusions to be capped at 50% of the total remuneration. So in case the allowances spill over 50% of the total cost to the company or CTC, then to the extent it spills over 50% is to be brought in under the definition of wages itself. So this is how the wages are defined, and we will quickly take one example, to understand how this will work for the purpose of deriving multiple benefits under the provisions or under the codes, which could include the calculation of gratuity, which could include the calculation for a maternity benefit, for example. So let's take an example where we have illustration 1 and 2 given on the slide, where multiple components exist. Say for instance, basic salary, medical insurance premiums, children education allowance, reimbursement, special allowance, performance bonus, etc. Then we have PF, HRA, LTA, conveyance allowance, and gratuity, which is payable on termination. So we have just tried and mapped some of the conventional elements of a payroll, which is generally persistent among multiple corporates. Now, if you look at the exclusions in this category, as per the definition of wages that we spoke about, what clearly gets excluded is PF, HRA, LTA, and conveyance. Now, for the purpose of our calculation, since my total remuneration is 108,333, let's take what is 50% of this. 50% of this would be 54,167. Now, I will have to ensure that my allowances, which are to be excluded, doesn't go beyond 54,167. Now in illustration 1, if we look at the total exclusions, which is reference number N in this table, the total exclusions is only adding up to 40,463. So therefore there is no need for me to bring in any conditional inclusion for the purpose of calculating the wages. Whereas in illustration 2, again, if you look at the specific exclusion for the purpose of 50% limit, it is 55,259, which means that the delta between 55,259 and 54,167, which is 1,092, that becomes a conditional inclusion, which I will have to add to arrive at the wages, or to arrive at the number which will be considered as wages for the purpose of calculating any entitlements, for instance, gratuity or maternity benefit in the case of female employees, etc., and for the purpose of any other entitlement as per the purpose of this code. So this is the entire essence, in some sense, on the definition of wages, and it's going to be very crucial as we go along all our discussions on the rest of the slides. To move forward, um, what are the other key provisions? Now, some of these are clearly repeats and coming as is from the previous form of statutes on labor law itself. For instance, equal remuneration, weekly days of rest, the normal working hours, which is 8 hours of work plus one or more intervals of rest, which shouldn't be exceeding 1 hour. Wage for overtime is something that we'll deliberate a little more in terms of how will overtime hours work. Will all employees be entitled for it? Similarly, in the case of bonus, also we will discuss whether all employees are entitled for those kind of bonus as well as overtime. Now, what is important again is that the code on wages fixes the wage period to be either daily, weekly, or fortnightly or monthly. And the code says that the state government will have to categorize the employees for the purpose of this wage period. They have clearly said that no wage period will exceed a month. So technically, a month is the largest span of a wage period for any category of employees. The timeline for payment, of course, in the case of a daily wage, it has to be paid at the end of the shift. In the case of weekly and fortnightly, at the end of the week or fortnight. And in the case of a monthly wage, it cannot go beyond the 7th day of the succeeding month. So this becomes an important aspect to note, that in the case of a monthly wage, it cannot go beyond 7th of the subsequent month. Two important aspects that we have to discuss is about full and final settlement. As I said, this could have a process impact as well as a P&L impact, or if not wholly on P&L, at least on the working capital side of things, because the code requires the settlement of full and final settlement to be done within 2 working days of dismissal, removal, retrenchment, or resignation. Now, of course, there are two ways of interpreting it, because it says within 2 days of resignation for that matter. Of course, in India, we have the concept of mandatory notice period. Now, we say that resignation is effective from a particular day, and of course, then the employee is required to service the notice period. Now, if one way to interpret that within 2 working days would mean within 2 working days, which would, say fall within the notice period, I would say it's a very impractical way of interpreting the law. But even if we were to say that we talk about 2 working days, which is beyond the completion of the notice period, I think it becomes very challenging, because there are multiple aspects, multiple data points which needs to be collated. There are handover of company assets, etc. There are multiple teams even within the organization which gives final clearance on some of the settlements. And therefore, if this has to come in the present form, which means that if the full and final settlement has to be made within 2 working days, then of course this becomes a quite onerous requirement on the industry per se. The second important aspect is about the applicable deduction. Now, the code on wages has clearly specified that there are certain elements of salary which only could be deducted. And beyond that, no other deduction can be made. For instance, if there is any fine, or if there is any loan or advance which has been given to the employee, then those kind of settlements can be made from the salary payout. Now, the two important aspects that one needs to know is, one, it says that the total deduction cannot exceed 50% of wages. it's a point for us to be mindful of. And second is if the deductions exceed 50%, then the excess has to be carried forward and recovered from the wages in the subsequent months. Now, let's take a practical scenario where, for instance, a withholding tax has to be done on the ESOPs when they are exercised. There are scenarios where, because the current fair market value of the stock options are way higher than the strike price or the exercise price, there could be a scenario where the withholding tax which the employer may have to do could exceed 50% of the wages of a particular month. Now, in those scenarios is where, because it specifically creates an embargo that the deduction cannot exceed 50% of a monthly wage, is where the employer may probably be in a dilemma as to how this has to be dealt with. The next is on payment of bonus. This again is coming from the Payment of Bonus Act, applicable to establishments which has 20 employees or more. Um, Two important considerations that one has to be mindful of is here that even after the minimum wages for the purpose of bonus is notified, there could be a scenario where the state governments can still notify a payment of bonus as mandatory for categories of employee who are still drawing the wages beyond those minimum wages. Now that is something that is currently not there in the statute. And the second important point is it again requires the employers to credit the bank account of the employee within 8 months from the end of the accounting year for the payment of bonus. So in some sense, the deferral of bonus cannot go beyond 8 months from the end of the accounting year. So this is an important aspect as far as payment of bonus is concerned. On the code of wages, there are requirements to maintain certain records. There are forms which are prescribed. Largely, these forms are similarly worded. They are similarly formatted as well. So the only thing that they have done is they have tried and subsumed multiple forms into one form just to avoid redundancy. But largely, the records and the registers and all the forms which are required to be maintained under these codes remain the same. The next aspect is on some of the penalties which can apply in the case of contravention. Now, obviously, there has been a larger attempt from the side of from the government side to decriminalize some of the offenses, but at least we see in some of the categories that there are imprisonment if there is a similar offense which is repeated over a period of time. The penalty for multiple offenses, which we have listed out on the slides as well, and we will share the slide pack with the participants post the webinar. The penalty ranges from 10,000 to 1 lakh rupees for multiple categories of offenses. And there are imprisonment for certain categories, as I said, for continued offenses in certain categories. As is the case, in the case of any statute, in the case of a company, there is a vicarious liability on the directors, which means that a person who is in charge for the operations of the company would be responsible and deemed to be guilty of offense, provided he is responsible for the conduct of the business. And of course, it is established that he was responsible for those non-compliances. So to summarize what we have on code on wages, as I said, I think what is important is this applies on both categories of employees and workers. Compensation structure, as we said, we will have to be mindful that the specific exclusions don't exceed 50% of the total remuneration. The full and final settlement that we spoke about to be settled within 2 working days is going to be a challenge. For the payment of bonus, of course, we'll have to wait for the state governments to specify the minimum wages and also the category of the employees to whom the statutory bonus has to be paid. And as I said, in the case of full and final settlement, I think there's a need to align some of the processes to ensure that if the laws were to come in the current form itself, where the employers will have to settle the full and final settlement within 2 working days, then of course there has to be much more efficiency brought into the system to ensure that all the clearances from multiple teams within the organization are all done within a time period of 2 working days. The next one that we have to discuss is on the code on social security. Now, the code on social security is actually a code that consolidates 9 laws. Something like ESI, EPF, maternity benefit, payment of gratuity, the Building and Construction Welfare Cess Act. So all of these are getting subsumed into the code on social security. Now, some of the glimpse or some of the highlights of the code on social security is one, there is a fixed term employment which gets covered under the provisions of gratuity, and we are going to talk about it a little more in detail. And the way the new category of workers in today's era, which includes all the platform and the gig workers, they have been brought into the ambit of the social security by way of the code on social security. Now, it's important for us to understand some of the key definitions. The first one to start with is the definition of employee. And the distinction is important because, as I said, some of the entitlements are applicable only to employees, whereas there are few which are applicable only to workers. While we discussed that, say, for instance, in the code on wages, all the entitlements that we discussed so far were applicable to both. So both of them were entitled. But as we move forward and Anjali takes up the other two codes as well, we'll see that there are certain aspects which are applicable only to workers. Now, if we look at the definition of a worker and try and compare it with the definition of an employee, I think what clearly comes out is that an employee and a worker could be distinguished only if the nature of activities that are to be carried on are in the nature of supervisory, managerial, or administrative activities. So if a person is doing a supervisory, managerial, or an administrative activity, then it is more likely that he or she will qualify as an employee and not qualify as a worker. So we have given the definition of all these four key terms, which is employee, employer, contractor, and worker, for the purpose of your reading. But just to summarize, I think the key differentials is only in terms of this three set of activities, which is supervisory, managerial, and administrative, that distinguishes a employee from a worker. In fact, the term worker is not even defined in the Code on Social Security, and we have taken the definition from the Code on Wages to ensure that wherever there is an ambiguity to understand who will qualify as an employee and who will qualify as a worker for the purpose of these codes, at least we know that the distinction is coming in terms of the nature of activities that one has to do. As I was mentioning, I think one of the clear highlights of the Code on Social Security is the way that the new category of workers, have been brought in for the purpose of Social Security. So what it mandates is that gig workers, platform workers, they also have to be brought under the welfare schemes, which relates to life and disability cover, health and maternity benefits, old age protection, education, and any other benefit. Now, for the purpose of this, the central government requires the aggregators to contribute 1 to 2% of their annual turnover to the Social Security Fund, which will be capped at 5% of the total amount which is payable to the gig and platform workers. Now, this is going to be an extremely important area for the employers who will qualify as aggregators, and aggregators have been defined clearly under the Code of Wages to include all the digital platforms. So the likes of food delivery platforms, uh, the ride hailing apps, logistics company, including the quick deliveries, online marketplaces, all of them will get covered under the definition of aggregators. And if one were to see what annual turnover would mean, annual turnover definitely is not defined under the code, and therefore in some of the cases, if the GMV is also to be included, then this 1 to 2% could be a huge amount. Of course, it is capped at 5% of the amount payable to the gig and platform workers. So we'll have to wait and see what it means to the employers who are aggregators. Similarly, for construction workers, a set is to be created which will be 1 to 2% of the construction cost. The construction cost definitely excludes the cost of land, which is an important exclusion that has to be contributed to for the welfare, the social security and the welfare of the building workers. Coming to EPF, I'll just cut it short for Anjali to take up the other one. So we'll talk about the headline changes here in terms of what EPF means to us. I think the contribution has now been proposed or reduced from 12% to 10%. So the headline change therefore would mean that the contribution towards PF is by default 10% of the wages, and only in certain notified categories will it be 12%, and those notified establishments have to be brought under the state rules. As and when the states will come up with the rules, that's when we will get to know which are the notified establishments on which this 12% will apply. The important part is on gratuity, as we said. Gratuity is now applicable for fixed term employment. So all fixed term employees are eligible for gratuity if they render the services under contract, for a year or more. Um, there has been a lot of confusion around this, so it's important that we understand that this is only for fixed term employees, doesn't apply to contracts per se. In fact, the condition of this 1 year is also coming from from the definition which is given under the Industrial Relation Code. Otherwise, the Code on Social Security doesn't even define the term of 1 year for the purpose of payment of gratuity to the fixed term employee. Another important aspect is the compulsory gratuity insurance. So, gratuity insurance has been made compulsory. So, for companies who just make provision for the gratuity without having maybe a surplus cash to honor the gratuity commitments at the end of the cycle for the employees, for them it is equally important that they also now look at how they are going to fund the premium for the gratuity insurance coverage. The next one is on maternity benefit. I think largely the provisions in terms of entitlements for a maternity benefit remains the same. Uh, a woman who has worked for at least 80 days in the 12 months preceding, it's already there under the current act. The maximum period of maternity benefit being 26 weeks is also there under the act. The key change here is the medical bonus amount, which has been, increased sparingly from 1,000 to 3,500. But an important aspect where a creche facility is being made mandatory for establishments which has more than 50 employees within the prescribed distance. Now, prescribed distance, of course, is not there under the code currently. Maybe states will take a call, and 4 visits are required to be permitted to the women employees during the day, and this 4 visits to the creche has to fall within the rest period of, or maybe beyond the rest period of 1 year, 1 hour within a particular day. So this is an important aspect as far as maternity benefit is concerned. Now, quickly, 2 illustrations. One is on the payment of gratuity and the one on calculation of maternity benefits. So as I said, for the purpose of gratuity, for instance, currently we were calculating gratuity only under the Payment of Gratuity Act, where wages was defined to include only basic plus DA and retention allowance. Now, because the wages have been redefined, we see that the amount of gratuity, because the entitlement here is calculated on 6 lakhs vis-a-vis 9,10,000 in under the Code on Social Security, which means that the total amount of gratuity will increase from 432 in this example to 656. This is again only on account of the realignment of the definition of the term wages, and it's important for companies to take note of this because this could have significant P&L impact. So maybe till the time the state rules are notified, it's a good opportunity for companies to do actual valuations wherever required and see what it means in terms of the overall increase in the provision that they need to make in the future for gratuity payouts. The second is in terms of maternity benefits. As I said, maternity benefits, again, because of the realignment of the definition of the term wages, gets reduced. I mean, this is one of the aspects where there's a reduction in the overall entitlement because the earlier calculation was to be done only on remuneration which was paid on payable, but it didn't include the specified exclusions. Now, because of the specified exclusions being there, we will take only basic, and we will add the special allowance on which the maternity benefit has to be calculated. So this possibly could lead to a reduction in the amount that is paid or payable. Forms and returns largely remain the same. As I said, they have also consolidated some of the forms here, as was the case on Code on Wages. Penalties here range in the range of 50,000 to 3 lakhs. Largely, it is dissimilar to the code on wages because the imprisonment cases here, are slightly higher as compared to what it was on the code on wages. So we have imprisonment, though, as I said, largely the government intends now to decriminalize most of the offenses which are in the nature of filing or procedural lapses. So we'll have to wait and see if, based on the representation from the industry, these are, probably relaxed a bit further. So just to highlight, I think the most important changes here are on the PF rate getting reduced to 10% from 12%, and on the realignment of the maternity benefit on account of the realignment of the definition of the term wages. Over to you, Anjali, for the balance two codes.
Thank you, Sandeep. So I'll take you through the two codes, though the basic objective of the four codes have been same, that we need to move on to the single registration. So similar is the provision under the occupational code as well, wherein all the existing registrations would be subsumed and you need to obtain only one single registration. If you have the existing registration, then upload in the Shram Suvidha portal. Once it is uploaded, it would be deemed that you have all the approvals in place. No need to apply for the new registrations or licenses per se. And once the portal is live, then we will be able to get to know more about it. Some of the more additional duties has been are casted upon the employer to ensure that what are the safety provisions in existing have been implemented properly. So safety committee need to be formulated. Women safety provisions need to be enforced so that women can work during the night hours as well. There has been the capping of working hours, which Sandeep mentioned that those are there in the code of wages as well. So we need to see that how best we can utilize those 48 hours which has been provided for the purpose of working hours, and half an hour of rest interval, which is required after every 5 hours of work. So existing policies need to be aligned, and we need to be very mindful, as Sandeep mentioned, that we need to ensure that what are the provisions being implemented or required for the purpose of workers and what is required for the employees. When we talk about that safety committee or women's safety or working hours, these are the specific provisions which have been mentioned for the purpose of workers. But there are certain provisions which are there for the purpose of employees as well. As we move on, we will talk about it. So contract labor, definitely the industries have been employing the contract labor, but now we need to ensure that contract labor is not engaged in the core activities. So contract labor is required to be engaged, but yes, of course, only for certain specific set of activities we can engage the contract labor for ancillary activities, but not for the purpose of the core activities. Core activity has to be done with the permanent employees so that they can ensure that all the benefits which are being required to be passed on to the permanent employees are being given. Only few of the exceptions have been provided wherein contract labor could be engaged in the core activity. For example, there is a spur in the demand, or there are certain existing requirements which are need to be fulfilled. So certain exceptions have been created in the law to fulfill the needs of the business. Then coming on to the easier compliance in a sense that because single registration, one return, and we know that ease of doing the business is being harped upon by all the statutory authorities as well as by the industries. So keeping in view, only the single return is required to be filed under this law. Non-compliance, as Sandeep mentioned, the decriminalization will help definitely, but we need to see that how far it is going to achieve the objective. It should not happen that certain kind of if you get a notice only to improve upon your compliances, but you are not penalized, then the industry might take it lightly, which should not happen, because self-governance, self-compliance is the focus of these laws as well. Coming to the definition, which Sandeep mentioned, that worker and employee. The thin difference basically is that if a person, whosoever is employed, whether with your knowledge, through contractor, through subcontracting, everyone would be deemed as the employee of the organization. But if the person is working in the supervisory capacity, he is drawing a wages of less than 18,000, then he will be considered as a worker. So first and foremost, important aspect which we need to see is to see the grades where our workforce is sitting, majority is workers or of employees. Then we need to see that whether what financial impact would be under the two codes and what would be the policy which would require to be redefined for the purpose of working hours, overtime, safety committees, etc., redressal mechanism committees. So those will depend specifically on the workforce categorization, which is the first step in any of the impact analysis that need to be carried out in these codes. Okay. So occupational health and safety code will be applicable to every industry, whether it's in manufacturing, whether it's in industry, trade, business, wherein 10 or more workers are employed. But earlier, for the purpose of factory, the definition was that where 10 persons are engaged, but now the limit has been enhanced for the purpose of factory to 20 workers with the aid of power and 40 workers without the aid of power. With the increase in the limits where the number of workers are employed, there might be a possibility that some industry may get uncovered through these provisions. But still, government has kept that into consideration, and any kind of a safety measures that are required or welfare provisions that are required. So any industry which is engaging more than 10 persons are required to comply with those safety provisions. So the government has well taken into consideration that safety is of prime importance. So these are few of the definitions Sandeep has already taken you through in the earlier slides as well. Retrenchment is the one field which has been harped upon by the government, that what kind of benefits we need to give if a person is retrenched. But we need to see that what constitutes the retrenchment, which is defined that any kind of a termination of service, but otherwise than by way of disciplinary action, that will constitute the retrenchment. And when the person is retrenched, there is a reskilling fund, need to create a reskilling fund for the purpose of providing the benefit to the retrenched worker. And this provision was never earlier there, but now this has been made applicable in the scenario of the retrenchment, that whenever the person is retrenched, the reskilling fund is required to be created, which is required to be paid to the retrenched worker. And if any vacancy which is created on account of retrenchment that is required to be fulfilled again, then within 1 year, the same person has to be offered that opportunity first. And if he denies, then only the employer can employ anybody else. So we need to see that if 1 year has been completed, then only the vacancy can be fulfilled by any other person. Next. Okay. So I already talked about this core activity in which the contract labor cannot be employed. Just keeping in view the time constraint, I'm moving little fast on the slides, but we are getting the questions on the chat box and we will try to address this as much as possible after the presentation. Okay. On the working hours, yes, 8 hours are permitted. Of course, we are moving towards the shift for the 4 days working, but 12 hours then need to be performed during that year. And we need to see that how best the employee could perform if the period of working hour is stretched up to 12 hours. The overtime which has to be paid, that is the twice the normal wage rate. We need to see that what are the monitoring tracking mechanism in place to track that how many hours he has worked for the purpose of overtime. Consent has to be obtained from the worker if he has to perform the work for the purpose of overtime. Only the 125 hours of overtime work can be performed by a worker during a quarter. Notice of period of work has to be displayed in the organization. Anytime the labor inspector could visit and see whether all the notices are in place, all the policies has to be kept in records, all the registers, specifically returns, need to be maintained in the premises so that the inspector, whosoever visits the premises, can see that records are in place. Encashment of leave. Earlier, the policies were that the leaves which were accumulated were being lapsed, but now the workers can approach upon the completion of the year to encash the leaves, whatever have been accumulated beyond the 30 days of leave, and 30 days of leaves can be carried forward. So whenever the workers approach the company, they need to encash those leaves, and we need to create a buffer for that amount which is entitled to any of the worker. in terms of encashment of leave. This is a snapshot of what changes have been, what are all the impact areas there. So health checkup need to be conducted for the purpose of employees who are there in the organization. Free health checkup need to be conducted, but there are certain conditions attached to it above the age of 45 years and what kind of checkups are required. So that are the more details which will come out in the state government rules. Definition of interstate migrant worker has also been broadened, whether the workers themselves migrate from one state to another or whether they are employed through the contractor. So everyone will come into the net of the interstate migrant workers and they will be entitled to the separate benefits which are provided in the Act. Then I think we have covered most of this. I'll move on to the next code, that is Industrial Relation Code. This is more to govern the employment or the undertaking, investigation, settlement, grievance mechanism. So I'll quickly take through the worker committee, which is required to be formed in this act, and the grievance redressal mechanism. Trade union need to be formulated, but now the negotiating trade union concept has been introduced, wherein any of the trade unions which have the support of the 51% of the workers instead of 75%, which was earlier there, those would be qualified as the negotiating trade union, which will have the kind of control or hold they can negotiate with the management. I'm just moving the slide so that you can also see the content. Just move on. Okay, strikes, there was the provision that only for the public utility, the notice was required to be given for the purpose of strikes. But now it is for all the industries that whenever the strike need to happen, the 60 days notice period has to be served. And within the period of 14 days, that strike cannot commence. Standing orders need to be adopted by the industries, and it's not only limited to the manufacturing, it's also extended to the service industry. So model standing orders are there. If you are going to adopt the model standing orders, then you are just required to notify to the inspector that you are going to adopt the model standing orders. But in case you need to redraft it, renegotiate it with your workers, then those need to be discussed, and then only this could be adopted by the organization. So two ways, either adopt the model standing order or have the your own model standing orders to be discussed and certified by the officer, then this could be implemented only. Okay, these are the retrenchment provisions I have already discussed about. But one of the important provision that whenever we are going to close any industrial establishment having 50 or more workers, then 60 days notice is required to be given to the appropriate government and to the worker who has completed the period of 1 year. In addition to the notice, this is the prior notice which was required to be given, 15 days of average pay for each completed year of service. Just like calculation of gratuity, we need to pay the compensation for because the industry is going to close, that compensation is required to be paid. But here the compensation not to exceed the average pay of 3 months. In case this closure is on account of the unavoidable circumstances or the financial difficulty. But financial difficulty will not mean if you are going to close the premises because you are not getting your lease extended, that will not lead to the unavoidable circumstances or the financial difficulties. So we need to keep into consideration if the lease is not getting extended, you have to make the compensation while closing of the industry. So this key provisions I have already talked about. These are the expanded definitions: workers, industry, strikes, layoff, retrenchment, standing orders. We have covered all this. One of the things is that the employer and workers should prohibit from engaging into the unfair labor practices. The employer should be mindful that they should not restrict the workers from framing the trade unions, or they should not threaten the workers for discharge or dismissal. Employers has to be very careful while communicating any such kind of a dismissal or discharge of services of any worker, because that could constitute to the unfair labor practices that need to be avoided. So these are certain broad key changes, and which are the objectives, broad objectives of these four labor codes are that decriminalization and compounding of offenses. This is really helpful for all the industries, that there would be a list of the imprisonments which have been replaced by the civil penalties like monetary penalties, fine, and even the compounding has been provided by way of the monetary penalty and fine. Inspector cum facilitator system has been implemented. You can be given the kind of a cautionary notice if you are not able to comply and reduce the harassment. That is also the objective under all the four codes. Digitization, once these codes are activated, the portal is live. Shram Siddha portal will see that one registration would be required, one return required to be filed. All the filings will happen online, and we need not to move department to department to file our replies or returns. So that would be additional facilitation thereon. Policies, we need to see that what new additional policies we need to make: working time policy, overtime policy, retrenchment policy, leave policy, equal remuneration policy, safety, women safety, and sector specific health and environment safety policies. So these are the major areas of focus which we need to focus, that how we should gear up ourselves for the purpose of implementing these codes. And we need to see that which provisions are getting effective immediately, and what are the provisions for which we need to wait till the states bring out their own set of rules with the which are more likely to be aligned with the central government codes. One of the things which I would like to highlight here is that some of the areas which need to be addressed is that, though there has been the increase in the threshold of number of workers from 100 to 300 for the purpose of retrenchment, layoff, closure, etc., but we see that there is a possibility that there is a biased hire and fire could happen, wherein the 300 or less workers are engaged. So, but this is the responsibility casted on the employer to prevent these kind of activities. Increase in the threshold in number of workers, again in the factories, same kind of thing, that there might be some kind of a reduced health and safety for the workers which are engaged in like 10 or less industries. There we need to see that how the employer prevents or protect the safety of the workers. Increase in the threshold of number of workers from 20 to 50 for the purpose of contract labor. So contractor will freely be entitled to engage the contract labor with less than of 50 workers. But they need not to obtain any kind of a registration and license. This is also one of the area of concern. Fixed term employment entitling all the equal benefits, that's that of the permanent employees, as well as the gratuity on completion of 1 year. There will be the reduction in the permanent jobs that we need to see, and this will weaken the job security as well. Mandatory 14 days prior notice for the strike. This will reduce the bargaining power of the workers and delay the grievance redressal as well. So that's some of the important points here which we need to address over a period of time. Maybe through rules, this could be clarified or something. State might come at their own to protect these things. So this was all from our side, and I think we are able to complete this in time. Last is the labor code implementation phases. So first phase would be the workforce categorization, as I emphasized in my presentation as well, that first phase would be the workers categorization. Then we need to realign our salary structure, payroll components, as Sandeep mentioned, that 50% should constitute what allowances would be counted towards the payroll. So that need to be aligned. Then we need to review how we shift from the working hours, what would be the shift timing, what would be the overtime practices. We need to update our systems as well. We have the online systems of punching in time out. So that also systems need to be integrated. And comprehensive overall review of HR policies is required. We need to prepare and update the standing orders as well, upgrade our system, and towards the end of the implementation, we need to realign our workforce strategies in line with the new codes, standardize and update all employment related documentation and contracts, and develop and implement a strong compliance and governance framework. So this is broad framework of how we could implement these codes, and we may uh, help you in this. Thank you so much for all of you. We have received so many of the questions. We are hopeful that after this webinar, we will collate all these questions and try to answer this. And we will send all these answers to all the participants. We have received the mail IDs and we will try to send this on the mail IDs itself. Sandeep, do we have some time to take quickly some of the questions if that time permits, though we are on time?
Yeah, I mean, I can see a lot of questions, so I think
Yes.
filtering that out itself, maybe one question that you can take up. I'm just going by the last first. It says, is it
Yes.
mandatory to constitute grievance redressal committee if employees are more than 200?
So we need to see that which industry they are into. There are specified industries in which this grievance redressal committee is required to be formulated. And there is a specific formulation as well provided wherein workers' participation is required and even the women participation is required as per the proportionate, whatever the number of women employees are there. So we need to see that which industry they are talking about. There are certain specific set of provisions which are required to be kept into consideration while forming the grievance redressal committee.
Right. Maybe one question that comes up towards the end is CTC includes fixed and variable performance pay. What will be the calculation? I'm assuming the attendee wants to understand how will wages be calculated. So as I said, we'll have to look at the total CTC and ensure that not more than 50% goes in the allowance component. If it is, then there are conditional inclusions. Of course, our slides will be shared with you, which has the illustration. But I think on an overall basis, what needs to be ensured is that the wages are, in particular defined under the code on wages, and the calculation for the purpose of calculating any of the entitlements has to be done as per the definition of wages, which is given under the code of wages itself. Right, that's it from my side, Anjali. I think thanks everyone for joining in. And we will, wherever we have got the email IDs along with the questions, we'll try and send you the responses to your specific questions. But please feel free to drop in a line to us as well or connect with us on any specific aspect on the labor code that you would want Anjali and I to cover subsequently. Thank you.
Thank you so much, participants. Thank you.